So thank you so much to the organizers for putting on this great event, to Grant, Phil, Paul, Forest Ethics, and so many of you that traveled to be here. On a personal note, it is so nice to be in a room filled of people who care about oil by rail and are following these issues. I first started working on these issues in early 2014 after I had done some work on hydraulic fracturing and was seeing the exponential rise in that, and then started seeing how this oil, especially in the Bakken, was actually being transported all across the country, going through states that, like New York, that actually hadn't even approved fracking within the state, and came to see this as really a significant public health and safety issue, also for states and people who really do not benefit from fracking and do not benefit from the oil that's exported. I then was able to work with the California legislature on some of their initial thinking about how to respond to the threat of oil by rail. And federal preemption came up immediately. And so I want to focus my remarks on just, first giving a brief overview of the federal regulatory scheme governing oil by rail, to give a baseline understanding of what we're working with and what federal preemption is. Then I will turn to focus on what states and local government can do to help protect their communities from this modern and emerging threat. I'm going to start out by, describing federal preemption, and I don't want you to be discouraged. Second part, we're going to get to, that states and localities retain a lot of their local police powers to protect public health and safety. So that's sort of the lay of the land. So as a starting point, the Federal Department of Transportation and its Federal Railroad Administration, or FRA, has primary authority over rail safety and transportation in the United States. This makes a certain amount of sense because railroads by nature cross throughout the country. They cross over various state lines. And one can imagine that if states had primary authority, it would be nearly impossible for railroads to operate seamlessly, efficiently, et cetera. So this is the baseline starting point. In a nutshell, federal preemption means that certain regulatory actions are the exclusive responsibility of the federal government, and states and local governments cannot regulate in those certain areas. The way that this specifically plays out in terms of rail safety and oil by rail is that two main federal statutes apply here. The first is the Federal Rail Safety Act, or FRSA, and the second is the ICC Termination Act, or ICCTA. A third component is the Commerce Clause of the United States Constitution, which effectively prohibits states from directly interfering with interstate commerce. That's also raised against various state and local pronouncements. So the FRSA expressly preempts state authority to adopt rail safety rules unless the Secretary of Transportation has not prescribed a regulation or issued an order covering the subject matter of that state requirement. So in other words, states have latitude to regulate where the federal government has not or has not yet done so. An example of what states have done under this exception is to require, most recently, two-person train crews. For example, California has put that forward. And also the requirement for rail carriers to have oil spill contingency plans for trains transporting oil into the state to protect state waters and public health and safety. In terms of the ICCTA and the Commerce Clause, I won't bore you with the details of the statutory and language there. The main thing to know is that states and localities cannot interfere with interstate commerce, and they cannot directly regulate train operations. This is a complicated area, and any sort of state legislation that is being considered, I just highly recommend those who are working on it to consult with policy experts and attorneys who can actually look into the case law in terms of what does this mean, and is what you're trying to do problematic in terms of how the case law has come out in your jurisdiction. So, in places like the West Coast, the Ninth Circuit really would control, and it would be very useful to look into that case law. Places like New York, the Second Circuit. So before moving on from this component, I'm putting myself in the shoes of a local or state policymaker. I would ask myself a few questions. Is what I want to do already covered by existing federal law? If not, that's pretty good. Is what I want to do interfering with interstate commerce or directly regulating rail transportation or operations? And then have I consulted with a legal or policy expert to kind of help guide my thinking on this? So So now let's turn to some things that state and local governments can do. And I'm going to start with prevention first, and then I'll turn to emergency response. So one of the most important things that states can do is that they share authority with the federal government for enforcing federal rail safety standards, and they can conduct inspections. And it's also up to the states to determine how many inspectors they have out on the field, and to put forward inspection schedules. Most states have hundreds, if not thousands, of miles of railroad track that run through their borders. Inspection is critical because the leading cause of derailments are broken track rails, broken rail wheels, and other various mechanical failures that actually can be found and are found during routine inspections. State budgets can also include funding to hire additional rail safety inspectors. And this can be paid for by rail industry assessments. California has done this, for example. The next thing that states can do, and arguably should do, is conduct a specific analysis of the risks that crude by rail poses to their specific state. So not every state or locality faces the same risks. Certain states and areas have rail track that crosses over important waterways for drinking water, et cetera. It's important to identify those specific risks and try to come up with potentially local permitting issues that can overcome those, if not even voluntary agreements with the railroads to try to reroute around those critical areas. The third thing that states can do in terms of prevention is to advocate for more stringent federal rail safety regulations. So Marcus quite aptly described the Rail Safety Advisory Committee, or RSAC. That committee actually has a spot for at least one representative from every state to come and advocate to Congress. And it's important for states to have that voice. Again, if funding is an issue, that could be supported through an assessment on rail transportation into state boundaries. The next thing is that states and localities maintain their traditional police powers to enact local land use and public health and emergency response plans. In the oil by rail context, what this means is that states can do things like issue guidance to local permitting agencies on requirements for offloading facilities and terminals and refinery expansion. As Matt noted, there are a number of new and proposed offloading projects and refineries, especially around the coast of the United States. Local agencies can deny land use permits for expansion or for new facilities if they find improper safety risks or improper environmental mitigation under state statutes, for example. An issue here, though, is that various local agencies may not have the same level of expertise in these issues. So again, it may be important for states to come out with guidance documents to tell them what exactly they should be looking for and when they can deny those expansion permits. Localities have a major role to play here, as they wield significant local police powers, and they can directly call on their constituencies, the citizens within their boundaries, to comment on any environmental reviews that are submitted in any expansion proposals or new projects. And in addition, advocacy groups like Earth Justice, Sierra Club, NRDC play a critical role in challenging approvals of new facilities that did not necessarily comply with environmental laws and holding them to a high bar. Another thing that states and localities can do, still on the prevention side, is to provide guidance to the public on how to effectively participate in the public commenting process. Commenting on an environmental impact statement or environmental assessment is a really technical, these are really technical long documents. So it may be a good idea for localities, cities, other grassroots organizations to come together and actually provide guidance on how members of the public can most effectively participate in that process. Identify opportunities to come and speak at public hearings. Apply direct pressure on railroads to enter into things like voluntary agreements. Apply direct pressure to encourage railroads to disclose information on how many trains are coming through, when they're coming through, et cetera. This is also critical because the property values of people who live near railroad tracks, we know actually can be negatively impacted and will continue to be negatively impacted as more oil by rail moves through their communities. So there's a financial stake as well. On the response end, states can do things like require oil spill contingency plans for trains that transport oil into their state. California, again, has required this now. This goes to both local traditional police powers as well as the federal railroad laws. While they have preemption provisions, they actually must be harmonized with other existing statutes, federal statutes, like the Clean Water Act. And the Clean Water Act and the Oil Pollution Act actually allow states to carve out and require their own specific contingency plans. And so if those two things must be harmonized, that leaves a window for states to do things like require specific state-level planning. The other thing that can be done under this harmonization aspect is for states to require proof of financial capacity to do any oil spill cleanup. And California, again, has added that to its legislation. Finally, I will just emphasize what my co-panelists have noted. It's hard to get all of the information that we all want. But one thing that states and localities can do to help this is to share the information that they do have. Under the DOT emergency order, railroad companies are required to at least notify state officials about the movement of long trains carrying Bakken crude oil. But states and localities can also share information about how they are responding to those threats. They can share model legislation or existing legislation. They can share recommendations for permitting guidance. And they can share the data that they have on the risks specific to their state. So I will just end on that note and look forward to your questions. Thanks.